Welcome to all. Today, as a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of information memorandum, request for resolution plan, and evaluation matrix. So, before that, let us discuss what we have discussed previously. In the previous classes, we have discussed about the committee of the creditors, powers of the committee of the creditors, and all other things we have discussed. Now, we are discussing the information memorandum. So, under the Insolvency Bankruptcy Code, the information memorandum is a critical document which is prepared by the resolution professional to provide comprehensive details about the corporate debtors' financial and operational status. So, what is the significance of information memorandum? So, information memorandum is a document which speaks about the corporate debtor in a simple language, which speaks about the corporate debtor. So, which contains the details about financial status, how it is operating, everything. So that based on the information memorandum, the resolution applicant, they are going to take the decision. Okay, the contents and preparation of information memorandum are governed by section 29 of IBC and regulation 36 of Insolvency and Bankruptcy Board of India IBBA, Insolvency Resolution Process for Corporate Persons Regulations 2016. Simply, it is also called as CRP regulations. So the provisions relating to information memorandum, we are having the provisions under section 29 read with rule 36 of the IBBA CRP regulations, CIRP regulations. Okay, so information memorandum is considered to be one of the essential document in the process of CIRP. Now let us discuss about section 29 of IBC. So section 29 of the IBC provides that the resolution professional shall prepare an information memorandum in such form and manner containing such relevant information as may be specified by the board for the formulation of resolution plan. So section 29 casts a responsibility on the resolution professional. Okay, if you observe section 29, okay, so resolution professional, it is shall, they have used the word shall. Okay, so the resolution professional, they shall prepare an information memorandum. So we are having the formats are there. So in the format, and we are going to discuss subsequently the contents of the information memorandum. So having such contents, he is supposed to prepare the resolution plan. Okay, for the purpose of resolution plan, he is supposed to prepare the information memorandum. So because based on the information memorandum only, the resolution applicant, they are going to prepare the resolution plan. Then in subsection 2, the resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form, provided such resolution applicant undertakes, these three are very important, okay, undertakes to comply with the provisions of the law for the time being in enforcement relating to confidentiality and insider trading. We'll discuss. To protect any intellectual property of the corporate debtor, it may have access to and not to share relevant information with third parties unless clauses A and B of this subsection are complied with. So what they are saying, so based on the information memorandum, generally the resolution professional, when it is asked by the resolution applicant or as prospective resolution applicant, if he is asking for any information, why? Because unless the resolution applicant is having detailed information, generally he cannot prepare resolution plan. So that's why when the resolution professional is sharing the information about the company, so this sharing the information can be in the form of physical format or it can be in the form of electronic mode. So depending on circumstances, he may share the information in physical or electronic form. Then please remember, whenever if any information is shared by the resolution professional to the resolution or prospective resolution applicant, he is supposed to maintain the confidentiality and he is not supposed to do the insider trading. So what is this insider trading? Based on this, suppose if the corporate debtor happens to be listed company, then based on the information that is received from the resolution professional, the resolution applicant or the prospective resolution applicant, he is not supposed to do the trading in the stock markets. Okay, so he is supposed to maintain the confidentiality. I mean, he is supposed to enter into NDA agreement and he is supposed to maintain the confidentiality and he is not supposed to do the insider trading. And he is supposed to protect the intellectual property of the corporate debtor. Why? Because as a part of the information memorandum, okay, he is going to share lot of information. Sometimes which is very crucial for intellectual property. So he is supposed to, the resolution applicant is supposed to protect the intellectual property of the corporate debtor. Then explanation. For the purpose of this section, relevant information. What is the meaning of relevant information? Relevant information means the information required by the resolution applicant to make the resolution plan for the corporate debtor, which shall include financial position of the corporate debtor, all information relating to disputes by or against the corporate debtor, and any other matter pertaining to the corporate debtor as may be specified. So if you observe the previous slide, okay, so if you observe the previous slide, and in subsection 1, the resolution professional shall prepare an information memorandum in such form and manner containing such relevant information. Okay, they have used the word relevant information. Then what is considered to be relevant information? Relevant information means anything related to financial position of the company. So when I am saying that financial position of the company, it can be a balance sheet, it can be cash flow statement, it can be any other document. Okay, so under the company side we are having books of accounts and financial statements. So it can be relevant information, can be books of accounts, relevant information can be financial information, financial statements. Okay, so books of accounts includes your ledgers, vouchers, everything is included within the meaning of books of vouchers, books of accounts. Whereas financial statements includes your balance sheet, profit and loss account, cash flow statements. So every such information is considered to be relevant information for the purpose of this section. Okay, so relevant information includes financial information, and relevant information includes disputes by and against the corporate debtor. So possibility is there, against the corporate debtor someone may have filed a case. So if someone file a case, if they win the case, then possibility is there the corporate debtor may end up in paying huge penalties, or else corporate debtor file a case against third party. Okay, if they are going to win, legal consequences will always be there. Okay, so these legal consequences are going to impact the resolution plan. So that's why you are supposed to give the information relating to financial position and disputes or any other matter. Okay, depending on circumstances, any other matter which is important for framing the resolution plan. Then, so if you observe the entire section, then you will understand that section 29 of the IBC is mandating the RP to prepare the information memorandum in such form containing such relevant information as may be specified by the IBBA, because IBBA, by framing the regulations, already they have specified the format in which you are supposed to prepare the information memorandum. So if you observe section, if you read section 29, you will understand that resolution professional is supposed to prepare the information memorandum in the form and in the manner that is specified by the IBBA. Now let us look at the level of regulations. Regulation 36 of IBBA speaks about the details and the contents of information memorandum. So the details, the specified contents required in the information memorandum, including we are supposed to give these information, assets and liabilities with their values. So in the information memorandum, you are expected to give the details of assets and liabilities. So what is the asset value, what is the liability value, what is their value, and along with the depreciation. Okay, so in case of assets, you are expected to give the details about the depreciation also. Then financial statements of preceding 2 years. You are expected to give the financial statements of the preceding 2 years. Already I told you what is the meaning of financial statements. Financial statements includes balance sheet, profit and loss account, notes forming balance sheet and profit and loss account, then cash flow statements. Okay, so this is included within the meaning of financial statements. So last preceding 2 financial years, you are supposed to give the financial statements. Then list of creditors and amount dues. Then details of guarantees and contingent liabilities. So if the company is having any contingent liabilities, and if the company have given any guarantee in favor of any other person, because there is a possibility if you give guarantee in favor of other person, then in the near future a liability may arise. Okay, so that is contingent liability. Okay, it may or may not come. Okay, so that's why you are supposed to give the details of guarantees and contingent liabilities. Then you are expected to give the operational details. Okay, so including business models and key contracts. Okay, so sometimes it is possible in case of few companies, some contracts are very huge, and where such contracts may contribute more than 50 or 60% of their revenue. So that's why if such contracts are there, you are supposed to give the information about those key contracts, because these key contracts are contributing to substantial part of your revenue. Okay, so that's why you are supposed to give these operational details also. Then let us discuss about key contents of information memorandum. What should be there? So first part in the information memorandum is corporate data details. So what is this corporate data details? Let us discuss in detail. So corporate data details includes your company name, your SIN number, corporate identification number, your register office, then your basic data. Okay, so company details, address of the company, phone number, mail ID, so basic data. Okay, then you are expected to give the financial information. Okay, so when you are giving the details of the financial statements, you are expected to give your net profits, okay, and profits before tax, profit after tax. Okay, what is the total cash flow, what is the total revenue, tax expenditure, total expenses, total income. So everything you are supposed to give. Okay, financial information. Then operational and business information. So you are expected to give the details about operational activities, your business information. Okay, so what is the core area where you are working? Okay, who are all your core customers? Okay, sometimes it is possible the company may have only few customers. So in such cases, you are expected to give the details about the few customers also. Okay, then debt structure and creditor details. So you are expected to give the details about debt structure. Okay, so in the debt structure, you may have various categories of debts. Okay, in the debt capital, you may have debentures, you may have loans, you may have bank loans, you may have deposits. Okay, debentures. So like this, so various categories are there. Okay, so you are expected to give the details about the debt structure. Then you are expected to give the details about the litigation and contingent liability. So if any cases are filed by the creditor, corporate debtor, or else if any case is filed against the corporate debtor also, you are expected to give the details about this litigation. Then key employees and management information. So you are expected to give the information about the key employees. Okay, when I am using the word key employees, maybe you can consider KMP, key managerial personnel. Okay, so generally key managerial personnel includes your board of directors and your managing director, whole-time director, manager, then your C-level people, that is CEO, CFO, COO, depending on the company, COO, company secretary. So all these people will be included in the KMP. Okay, you are expected to give the key employees, okay, who are all like acting as a foundation to the company. Okay, so that the resolution applicant can assess depending on the employees. Then you are supposed to give the details about resolution process. Okay, how the process is going on. Okay, what is the timelines. Okay, so in the previous classes we have discussed about the various timelines, okay, within which you are supposed to submit and within which you are supposed to complete. Okay, so resolution process, timelines, and bid requirement also. Okay, so you are expected to give the bid requirement. Then other material information. Okay, so here the material information is subjective in nature. Okay, depending on circumstances you have to interpret. Okay, so depending on the company, so whatever is relevant information, you are supposed to give the details about the relevant information. So let me take one example. Suppose take the example of thermal power plant. Okay, in case of thermal power plant, your material information can include who is supplying the raw material, that is who is supplying the coal. Okay, and with whom you are having an agreement for the distribution. Why? Because when power is generated, obviously you are not going to transmit. Okay, the transmission will always be done by the transmission company, that is transcos. Okay, government is having transcos. So in each and every state, in each and every region, separate transcos will be there. Okay, so with whom you are having an agreement. Okay, and with whom you are having an agreement to supply the coal, and with whom you are having an agreement to get the water supply. Because unless you are having the water supply, generally that's why generally majority of the cases thermal power plants are established near to the sea, near to the rivers. Why? Because you are expected to have the water supply. Okay, so with where you are having the from where you are having water supply. So these are all the basic details to be given. Okay, so that's why you are expected to give all this material information. Okay, then confidentiality and access. So this is very, very important. Okay, so please remember, whenever if any resolution applicant is applying for the information, or else if he needs any information, as already we have discussed in the section 29, the resolution applicant must sign a confidentiality undertaking. Generally it will be in the form of NDA, non-disclosure agreement. Okay, so because the resolution applicant is accessing the data, okay, that belongs to the corporate data. So that's why the resolution applicant is expected to sign the document stating that he is not going to disclose the information that he has received as a part of this. He is not going to disclose to any other third party. Okay, so the resolution applicant must sign a confidentiality undertaking before accessing the information memorandum, so ensuring that sensitive information is protected. Okay, so there is a basic objective of NDA agreement. Then let us discuss few practical aspects in preparing the information memorandum. Okay, so these are all the few practical tips or few practical points that you are supposed to consider whenever you are preparing the information memorandum. So first one, data collection and verification. So whenever you are preparing the information memorandum as a resolution professional, okay, the resolution professional is expected to collect the data and he is expected to verify the data. So from where he can collect the data, there are so many various sources are there from where he can collect the data. So he may collect the data from the ROC, that is Ministry of Corporate Affairs. So he may do the public inspection. Okay, when he is doing the public inspection, so if any forms are filed with the Registrar of Companies, that is uploaded with the MCA website, Ministry of Corporate Affairs, all the documents can be verified. Okay, so all the documents can be downloaded by going for public inspection. That is one mode. And another mode can be you can download the data or you can get the data from the information utility. Okay, so this is also one of the modes. So like that you can get the data from board of directors. So like this you can get the data from various sources. So data collection is one of the big tasks that you are supposed to undertake. Okay, then subsequently the data that you are getting you are supposed to verify. Okay, verification is also very important. Then classification and treatment of claims. So as already we have discussed, the creditors can be of two categories, financial creditor and operational creditor. Even in the financial creditors also you can have various categories. Okay, so various classes can be there. So whenever you are receiving the claims, in the previous classes we have discussed how to announce for how to go for public announcement. Okay, after public announcement how to claim the amount from by the operational creditor, by the financial creditor, various categories of the claims we have discussed in the previous classes. Okay, so based on the information, okay, the resolution professional is supposed to segregate the information. Okay, so this class this money, this class this much of amount. Okay, so you are supposed to do the classification and treatment of claims. Okay, then confidentiality and information access. So whenever you are giving the information to any resolution applicant, please ensure that you are expected to enter into NDA agreement. Okay, because the information that he has received must not be disclosed to third party. Okay, because if he is disclosing to third party, it may impact the company's interest adversely. So that's why you are supposed to ensure that confidentiality and information access is maintained. Then treatment of operational aspects. So whenever you are giving the information memorandum or preparing the information memorandum, please consider the operational aspects also. Okay, so how you are going to treat with the operational aspects. So because if you want to continue the business, okay, some essentials may be supplied to you. Okay, then how you are going to deal with that essentials. Okay, these factors must be discussed and considered whenever you are preparing the information memorandum. Okay, then asset valuation and disclosure. Okay, so in the next class we are going to discuss in detail about the asset valuation. Okay, so how to do the asset valuation, what is the methodology to be followed, whether you need to appoint the valuer or not. So these things we are going to discuss in the subsequent lessons. Okay, so next lesson we are going to discuss. So before preparing the information memorandum, you are expected to do the asset valuation and disclosure. So generally whenever the company is preparing the annual report, you are going to disclose your assets and liabilities, and in the form of notes to the balance sheet and profit notes to the balance sheet. Okay, so profit and loss account generally will have only expenditure, income and expenditure, but whereas balance sheet will have all the assets. Okay, so this valuation you can identify from the notes that is attached to the balance sheet. Okay, then subsequent to that, even under section 134 of the Companies Act, when you observe section 134 of Companies Act, the board of directors are expected to give the report that is called as directors report. In the directors report also they are going to give the disclosures. So please observe the disclosures made by the board of directors. Okay, so this is another important aspect. Then litigation and contingent liabilities. Okay, so whenever you are preparing the information memorandum, so let me call it as IM, so information memorandum, you are supposed to give the details about the litigation. Okay, so whether company filed any case against any other person, whether any other person filed a case against the company. So these things must be considered, and they should be disclosed at the IM. Okay, then ensuring compliances with the IBBA regulations. Please remember, prima facie, it is the responsibility of the resolution professional to ensure that he is complying with the IBC. Okay, so IBBA, when you are preparing information memorandum, detailed rules and regulations are there. Okay, so what to be disclosed, what not to be disclosed, and how many days you are supposed to take. So for all these things, IBBA, they having rules and regulations are there. So ensure that you are complying with the IBBA regulations also. Okay, then presentation and structure for resolution applicants. Okay, how they are supposed to present. Okay, how to structure the resolution plan. So you may be expecting something. Okay, so please give details about your expectations also. Okay, then digital data rooms for the resolution applicants. Okay, so please give the digital data rooms for the resolution applicants. Then handling post IM disclosures and updates. Okay, so post, once if you give the data in information memorandum. Okay, so post disclosure. So how you are going to handle the post IM disclosures. So already something is informed through the prospective resolution applicants. Then how you are going to handle. Okay, how you are going to give the updates about this. Okay, so these things must be considered before preparation. Okay, why? Because once if you issue the memorandum of information memorandum, okay, subsequently you cannot do anything. Okay, so before issuing or before preparing the information memorandum only, you are expected to observe and plan in advance regarding all these things. Okay, then now let us discuss few other important aspects in the information memorandum. Assets and liabilities, including contingent liability with such description as on the insolvency commencement date, as are generally necessary for the ascertaining their values. So whenever you are giving the information, or whenever you are preparing the information memorandum, you are expected to give the details as to assets and liabilities. Okay, so when you are giving the details as to assets and liabilities, even you are expected to give the details as to the contingent liabilities also. Okay, so contingent liability means right now there is no liability, but we are not sure whether in the near future it may come or it may not come. Okay, so the liability may arise or may not arise. Okay, so in the case of Kushal Limited case law, NCLAT held that the word description, because if you observe the heading, okay, that's why I have kept the heading like that. Okay, with such description. Okay, if you observe the second line of the heading, with such description. So what is the meaning of such description? The word description includes the details such as cost of acquisition. Okay, because when you are giving the details as to the assets and liabilities, what is the cost of acquisition? Okay, maybe appreciation may be there or depreciation may be there. Okay, so generally in case of flats, appreciation may be there, but generally in case of other assets, depreciation will be there. Okay, so that's why you are expected to give the details as to cost of acquisition and other useful information like identification number, depreciation of the charge. Okay, so you are supposed to give the identification number also. Okay, and depreciation, how much depreciation is there. Okay, everything you have to give so that the prospective resolution applicant can understand the real and exact picture of the assets. Okay, then in another case law, Puneet Kaur versus KV Developers Private Limited. So in this case law, NCLAT held that the term liability includes liability to pay money or money's worth. So what is the meaning of liability? Here liability means liability includes liability to pay money or money's worth. Sometimes it is possible you are liable to pay something. Sometimes it is possible you are liable to transfer something. You may not pay money, but instead of money you are paying something else. Okay, so that is called as money's worth. Okay, and it includes liability for breach of trust. Okay, or any liability in contract, tort, bailment. Okay, so there is a possibility in contract, suppose if you breach anything, you are supposed to do something. Okay, so even in case of bailment contract, even in case of torts. Okay, so tort means civil wrong. Okay, so in case of tort, bailment, contract, in case of breach of trust, possibility is there the corporate debtor may be liable to pay something. Okay, so he is liable to do something. Okay, so that is the meaning of liability when they are using the word assets and liabilities. Okay, so I think you are clear with the meaning of such description, the word such description that is used in the section, and the liabilities that is used in the section. Okay, now they have used another word. Okay, latest annual financial statements and audited financial statements of the corporate debtor. Okay, so they have used the word latest financial statements. Then in one of the case la, state of Karnataka versus Alok Kailash Saxena. So in this case la, NCLT Bangalore bench held that. So the resolution plan is not asset takeover. So though in the previous slide we have discussed that in the information memorandum you are expected to give the details about assets and liabilities. But only with assets and liabilities we cannot do anything unless you are having the detailed financial statements. Okay, so that is why I have given the word financial statements also. Even in the section also they have used the word financial statements. So why? Because if you are having only assets value, so it won't make any sense, or you cannot make a informed decision. So that's why, okay, so giving asset value is not sufficient. Okay, so because the resolution plan is not asset takeover, they are not only taking over the assets, they are taking over the business. So that's why, okay, the viability of the business is of greater importance than the asset value. So that's why giving financial statements is mandatory to make the informed decision. So why we need to give the financial statements? If I am giving the financial statements, you can understand assets, liabilities, cash flow statement, how cash is coming, how cash is going, and other liabilities, how you are providing the depreciation. Okay, how you are even if you observe the financial statements, the auditor must have made some comments. Okay, so whether are you maintaining the inventory management properly or not, okay, whether inventory management is proper in your company or not, he must have made some qualifications. Okay, so then all these things you can understand based on the financial statements. Okay, because financial statements includes your auditor's report also. So in the auditor's report, if CARO is applicable, companies auditor's report order, then auditor must have given some comments. Okay, so these comments are very essential to understand and to make a proper decision or informed decision as to whether to acquire the company or not. Okay, so that is why you are supposed to give the financial statements. Then you are supposed to give the creditors, list of creditors, names of creditors, etc. Okay, so in the case of Brothers Lorry Transport Service versus MP Distilleries Limited, Supreme Court held that. So while preparing the list of creditors, it is very essential. Why? Because the creditors are the people actually who filed a case, or possibilities there who might have initiated the case. Okay, so when you are settling the amounts, especially when you are talking about the waterfall mechanism under section 53, so first creditors are going to receive the money. Okay, before that anyway, resolution cost is there. So first we are going to pay to the resolution cost. Subsequently, first you are going to pay the amount to the creditor. So that's why the resolution professional, he shall take utmost care to include all the claims in the information memorandum. Okay, so he is not because as already we have discussed in the previous classes, the financial creditor and operational creditor, they can submit their claims. Okay, so the resolution professional, he shall compile and collate. Already we have used these words. Okay, so he has to compile and collate all the claims in the information memorandum without fail, and he should avoid any pendency from his end in consideration of claim. Okay, so if any claim is coming to the office, he is not supposed to keep it in the pending. Okay, so he should consider everything and he should try to include depending on the nature. Okay, so he cannot maintain all the claims in one place. Okay, so segregation must be done. Then suppose provident fund, gratuity fund, or other funds maintained by the corporator, so will it be included in the assets? No. Okay, because provident fund, gratuity fund, other funds, okay, though that is maintained by the corporator, but that belongs to whom? That belongs to the employees. Okay, that's why whenever you are giving your assets and liabilities, so in the previous slide we have discussed that the information memorandum should give the details as to assets and liabilities. So when you are giving the details as to the assets, okay, maybe sometimes it is possible the corporator is maintaining the funds. So though the funds are there, but such funds does not belong to the corporator. So that's why the provident fund, gratuity fund, other funds which are maintained by the corporator, so not to be included in the assets of the company. Okay, so they are not part of the assets of the corporator. Okay, then whenever you are requesting the resolution plan, okay, so these are all the common steps to be followed. Okay, so first one, setting the time limit for seeking any clarifications from the resolution professional. So you are giving the information memorandum, you are seeking the resolution plan. So if resolution applicant or prospective resolution applicant wants to seek any clarification, you should set the time limitation within which you are supposed to give. and you are supposed to give the evaluation matrix also. Okay, in the next lesson we are going to discuss about the evaluation matrix. So you are supposed to give the evaluation matrix or any other connected matter with the CRP. Then setting the time limit for issuing such clarifications. Okay, so when you are asking, or else when the resolution applicant is asking, within what time, or within, I mean, what is the time limitation within which the resolution professional has to give the clarification. Okay, then confidentiality agreement. Okay, so you are expected to enter into confidentiality agreement. Then the manner in which resolution plan should be submitted, how to submit the resolution plan, and the time within which the resolution plan must be submitted. And in the previous classes we have discussed that if any resolution plan is submitted after the expiry of the period, then that need not be taken, that will not be, or that shall not be taken into account. Okay, so that's why within the, what is the time limitation within which you are supposed to submit the resolution plan. So everything must be given in the information memorandum. Then documents which should be submitted along with such resolution plan. Okay, if you are having any documents to be there, so even such documents must be submitted along with the resolution plan. Then format of any declaration affidavits. Okay, so as already we have discussed in the previous classes, under section 29A, certain categories of the people, they are disqualified to be resolution applicant. Okay, so you are supposed to give a declaration that I am not disqualified. Okay, so there are certain formats are there. These formats must be given. Then requirement to submit any performance guarantee upon the approval of the resolution plan. So once the resolution plan is approved, then the resolution applicant should ensure that he is implementing the resolution plan. Okay, so in that process, he may have to give the performance guarantee also. Okay. Then condition based on which COC will negotiate. Okay, so because once the resolution plan is submitted, COC will start negotiating with the resolution applicants. Okay, so there must be some conditions. Okay, they must have had certain, maybe certain checklist must be there, maybe there. So based on which they are going to negotiate with the resolution applicant, you are supposed to specify. Okay, then evaluation matrix. Okay, so even you are supposed to give the evaluation matrix and criteria for evaluating the score of the resolution plan. Okay, then other conditions like right of the COC to scrap the process and reject the resolution plan. So possibility is there, they can scrap the entire process and they can go for liquidation. Okay, then you are supposed to give the evaluation matrix. So what is this evaluation matrix? There is a definition is there. Evaluation matrix means such parameters to be applied and the manner of applying such parameters as approved by the committee for consideration of resolution plan for its approval. So whenever the resolution plan is submitted, there must be some evaluation matrix. Without evaluation matrix, you cannot assess. Okay, so that's why they are going to fix certain parameters. So these parameters are considered to be evaluation matrix. So in the case of IMR, Metallurgical Resources AG versus Ferro Alloys Corporation Limited, NCLAT held that the approval or rejection of resolution plan will depend on the commercial wisdom. Okay, so please remember how they are going to assess. They are going to assess based on the evaluation matrix. Okay, so based on the evaluation matrix, if COC has taken the decision, such decision cannot be questioned. Why? Because commercial wisdom of the COC is paramount, as already we have discussed and we are discussing from the beginning. Okay, so commercial wisdom of the COC is paramount. So that's why we cannot question anything based on that. Then in another case, PNC Infratech Limited versus Deepak Maini, NCLAT held that the bidder who came in second is selected. Then there is no contravention because it is up to the COC. Okay, so maybe first bidder, second bidder may be selected. Okay, so it is up to the discretion of the COC. Now let us recap. Okay, so what we have discussed till now. So till now we have discussed what is information memorandum, then contents of information memorandum. Already we have discussed what are all the contents of information. Then request for resolution plan. Whenever you are requesting the resolution plan, what are all the various common points to be considered while requesting the resolution plan. Then common steps involved in requesting the resolution plan we have discussed. Then we have discussed the evaluation matrix. Thank you.